The next case to come before the court is, I want to pronounce it Wiesen, is that correct? Or is it Wiesen? Wiesen? Wiesen versus Wiesen. You probably both remember, but I need to go over the ground rules. You each have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes. And obviously the monitor's over there. And I'm just going to be using the top circle. So whenever the appellant pauses the argument, then that's the amount of time that will be left. Also, please don't mention the names of any children. I know victims are not relevant here in this case since it's not a criminal case, but nonetheless, I just remind everybody, no victims and no children's names. Please refer to them as child or as an initial. We are videotaping, so you need to keep your voice up as well as stand right there in front of or behind the microphone and the podium. And with that, you may begin once you tell me how much time you want to reserve.
Thank you, Your Honor. I will reserve 5 minutes of time for rebuttal. May it please the court, Attorney Corinne Hoover on behalf of the appellant, Robert Wiesen. We are here today in front of you from an appeal from the divorce case. The persons involved in the divorce case were both of relative modest means. Both were, by all accounts, hardworking small business owners, both operating businesses out of their home. We are here today because the trial court made a finding that husband engaged in financial misconduct, mainly in allowing a land contract entered into by the parties to expire or to not come to fruition. So these parties, shortly after they were married, entered into a land contract for the purchase of a home, in which case they would pay periodic payments of a set amount, and then at some point at the end of that contract were to pay the balloon payment in order to secure the residence and change title to themselves. In this case, at the end of the expiration of the initial term of the land contract, the parties were to submit a balloon payment of approximately $87,000. The testimony in front of the trial court was that husband was unable to secure financing in order to secure the title owner. And so the parties were able to extend the land contract for another year and a half. At that period of time, again, well prior to this divorce action, the parties were unable to secure financing for that balloon payment at that time because husband's business was being sued. Fast forward, the parties filed for divorce a year after the second land contract expired. At the time they filed for divorce, they were merely tenants on a month-to-month lease, not a written lease at that point in time, because they had not been able to secure the financing and to move forward with the title ownership pursuant to the land contract deal. Notwithstanding that, however, the trial court made a determination that husband, because he failed to secure financing for the land contract during the marriage, that he committed financial misconduct in dissipating an asset of the parties. We are here today because we believe that the trial court erred in both a matter of law and in factual considerations in reaching this finding of financial misconduct. The issue of financial misconduct, the definition of financial misconduct is well defined in the relative portions of the revised codes as it relates to marital property. Specifically, the Ohio Revised Code, which mentions financial misconduct, is 3105.171E. In that, it defines financial misconduct as dissipation, destruction, concealment, non-disclosure, or fraudulent disposition of assets. Further, case law has expanded that definition to also state that this necessarily implicates wrongdoing, such as one spouse's interference with the other's property rights. Wrongful intent or scienteer is required. Here, there is a significant gap, or I believe an overreach, of the trial court's findings that husband engaged in financial misconduct for not securing this land contract deal. First and foremost, and I will say this is probably my own personal view first and foremost, but I believe the finding of the trial court was misogynist in some extent here. The case law well defines that the benefits of a marriage are sharing equally in the benefits of a partnership as well as the disadvantages of that partnership. And as this court is well familiar, this court has issued several decisions in regards to marital debt over the last several years, further defining marital debt in the allocation, given that the statute requires a trial court to address marital property but doesn't specifically consider debt. This court, however, as well as the Ohio Supreme Court, has expanded that definition and has indicated that marital debt is also something that has to be divided pursuant to the section. Here, the trial court's finding that husband committed financial misconduct by not securing the finances puts all financial burden of a marital partnership on husband. And I believe that's very contrary to the case law. The case law indicates that when parties are married, their assets and debts are to consider the joint efforts of both of them. So the fact that husband was unable to secure financing leads the question is, what was wife able to do? Wife was working at the same time as well. Why could wife not have secured financing? If it was because these people of modest means, working hard, trying to build businesses, simply could not afford to come up with this balloon payment or the financing to secure this land contract as to a titled asset, then that burden should fall on both those parties.
Didn't the trial court determine that he was not being truthful when he said he couldn't obtain that financing, that he obtained other financing for a truck?
I don't believe the trial court made that.
And that there's no proof that he ever tried to apply for financing.
I don't believe the court made the finding that he was being untruthful. They said the testimony conflicted. Husband said he tried to apply for financing. Wife said she didn't know. Wife said she relied on husband telling her that, but she's not sure. I think it lends, though, at the same time, is that wife also could have participated in trying to secure that financing. Husband did, to further address your question, Your Honor, did, however, purchase a vehicle during that time. The purchase price of that vehicle, the down payment was $12,000 and was paid for his business. He's a remodeler. He purchased a truck that he testified was necessary for the operation of his business and being able to remodel and rehab houses. Interestingly, however, there was no testimony at all that had husband not put down a $12,000 payment that he would have been able to qualify for a loan. There was no expert testimony whatsoever, and in fact, wife did not provide any testimony to the contrary on that either.
Let me go back to what you were talking about before in regard to his testimony regarding his efforts to acquire a loan, the refinance of the land contract sale, and actually have the home in their legal custody. Right. Anyway, so he testified that he had tried and was unable to because of his poor credit score.
Correct.
Okay. Was there any I remember from the briefs, nothing was presented, any exhibits or anything, correct?
Correct. Not on that.
Did he testify to whether or not he used wife's credit or her income in regard to trying to obtain the loan?
There was no testimony on that whatsoever.
So,
By either party.
So he didn't testify that he solely used his income?
No.
But he said, can you infer that from the fact that he said he has such a poor credit score?
I think the bigger issue is both of these parties were low-income earners. As far as their tax returns, which were admitted as exhibits, is while husband had gross receipts for a business one year of about $250,000, annual income earned from that was only $40,000. Wife, on the other hand, testified and submitted exhibits that she earned a mere $13,000 in her business endeavor, and then at some point sought a second job to supplement her income.
Okay, so in regard to the truck that Judge Lansing was asking you about, at the same time he was able to acquire solely in his name,
Correct.
a truck that was cost, I don't remember exactly, but $57,000 or something like that. And if you have such poor credit, how do you do that? Because of the fact that that is going to depreciate.
Very good
Whereas
question, Your Honor.
whereas a house has equity.
Very good question. The truck was secured during the marriage prior to the time the husband was sued and there was a judgment granted against his business and him personally.
The truck was, now say that again.
The truck was purchased from husband's business prior to the time that husband was then sued and a judgment was granted against his business.
Okay, so it wasn't sold in his name, it was in the business name?
The truck, I believe the testimony was husband had to personally guarantee the truck. I believe title was held in his name individually, but the payments of which were paid from the business and were discounted as a business expense on his tax return. There was also testimony that the use of the vehicle was 90% business, 10% personal, and that was also reflected on their returns.
So when husband broke his land sale contract, was he evicted or foreclosed upon?
No, so he was making the required monthly payments.
So he stayed there, paid the payment, improved the property.
And I'm sorry?
And improved the property, right?
Improved the property, yes. And most improvements were made prior to the time where the second land contract failed.
And so is there some evidence on the record that the land sales contract was actually still in effect?
No. The other party to the land sale contract testified that it had not been in effect for at that point well over a year.
But that anything was possible after the divorce?
He did indicate that he could renew a contract, that there had been discussions about that, and also that the other part was that they had talked about vacating the residence. So
And
we set this up
if
in
you
that.
do pay a significant portion, 20% on a land sales contract, doesn't that become an asset? Because you also need to be foreclosed upon at that point?
I don't believe, the terms of the land contract were that they were paying the monthly payment, and if they could not meet the balloon payment, the contract terminated.
So if he stops paying the payment, then your argument is that it's not an asset.
Correct.
But if there's still a secret contract going on.
If there was a
becomes
secret
an asset.
contract, I would think very differently. I think the reality, however, is that the other party testified that there was not, and that the land contract had failed on 2 different occasions. And then he had kept them as month-to-month tenants thereafter.
There's other allegations too, or there's other things the court talks about as being financial misconduct, or besides that, correct?
Correct. There are. One of which is the purchase of the truck, which I think that we have already addressed there. The other part was that a vehicle was sold during the tenancy of the case in violation of the mutual restraining order. That trial court decided that wife should be allocated half of the sale value. We are not raising that as an issue on appeal.
If even 1 or 2 of these financial misconducts are substantiated, would you agree that the court has wide discretion in how she rectifies that in terms of distributive awards?
I do, yes, if the court finds financial misconduct on one of those, I do think that they have discretion then to allocate marital debt and assets thereafter. However, I also believe that based on the allocation is that then ultimately husband was found to be responsible for $178,000 in marital debt, whereas wife was solely responsible for $3,500 in debt. That in combination with ultimately a spousal support award and a division of property, I think is the issue. So they found that wife was entitled to $115,000 of equity in a property that husband did not own. So I think that's the other issue, is that taken in combination of all those, if the court had found financial misconduct, do they have the ability to make a distributive award? Yes. However, that the amount of debt allocated to husband and the amount of assets allocated to wife still tips that very disproportionately beyond what a distributive award would allow. Oops, I will reserve the remaining time.
I know,
unless you have
I
a
was gonna
question.
say, I was not gonna stop you because you were answering questions, but you still have just a little over 2 minutes.
I will reserve the rest of my time. Thank you.
Good morning, Your Honors. My name is Attorney Ken Crislip, and I represent Michelle Wiesen in this case, the appellee. And I would like to begin my presentation by simply stating that actions will speak louder than words in this case. And I think Mr. Wiesen's actions certainly spoke a mouthful for what his intentions were in this case. We go back to the party's first land contract and his inability to secure financing. Well, that's a very telling moment because Mr. Hoyt, who was the individual who owned the land or owned the property, who engaged in the land contract, amended it and gave them yet another year with slightly different terms, but basically the same thing. While they were living there, this place, when they first bought it, was literally uninhabitable. They couldn't get a mortgage on it in the beginning because it was uninhabitable. There was dead cats in the house, there was no running water, no sewage, nothing. They put so much work and effort into this home, not just money, but time and effort to make this home an habitable place. And this took place over the course of the marriage. During the course of the marriage, what was very clear in the record, and what was, I think, a big issue that arose here and something that Judge Cook took into consideration, was the volatility of the relationship between these two folks. They fought all the time. He was having an affair.
Why is that relevant?
Well, it's relevant, Your Honor, in the sense that he is not being honest with his wife. And part of the financial misconduct allegation was that he was using marital funds to go on vacations with this other woman and diverting those funds while the divorce was pending from wife. He was ordered to pay $400 a month in temporary spousal support and not make one single payment. But had enough money in his business account, which only he had access to spend and basically use that account as a personal account. It was not simply used for business expenses. He used it as his own personal account, and wife had no access to it. So for the second term of the land contract, again, he was given an opportunity to try to secure financing. He said that he tried to secure financing, but was not able to produce any documentation that would show that he made an application and that a bank denied him. Not a single one. This is a year prior to the filing of the divorce, which the appellant filed the divorce, not my client.
Was there a discovery requesting? Was there any discovery requesting applications or anything?
Yes, there were, Your Honor, and there was none produced because none existed. It was simply his testimony, and he offered nothing at trial to support his testimony that he had made efforts and was being denied.
So you're saying in response to discovery, his attorney, and he replied that there were no applications?
That would be my understanding. I was not the trial attorney on the case, but there was no applications presented as evidence, nor was there any application presented during the discovery phase of the case. So at that point, I think that his credibility is in question because continuously they are putting money into this property. He runs his business out of this property. After the temporary orders hearing, my client vacated the property. He remained. He is still there to this day. Something that the court may have noticed, and I put it in my brief, that in December of 22, he put $115,000 worth of siding on the home. Now, this would have been after the second land contract terminated, while he was living there as a quote-unquote month-to-month tenant. Mr. Hoyt said he was always open to renegotiating the land contract. But by this point, we believe that Mr. Wiesen had already, in his mind, knew he was going to file for divorce. And he also knew that if he created another land contract, he would be then responsible for dividing half of the marital assets with Michelle.
Was the land contract admitted into evidence?
I believe both of them were.
Okay. And was that actually filed? I mean, with the county reporter?
Your Honor, that I don't know. I don't know if that was actually filed with the county reporters or not. I do know that it was introduced in court as evidence. The court didn't make specific reference to it.
Okay, I just didn't remember. Going back to Judge Lansinger's question, because I thought that was an excellent question, but I don't think either side addressed, and about the foreclosure requirement if there's 20% equity on a land contract.
Can you refresh my memory what the question was?
Well, Judge Lansinger, do you mind asking?
Sure, I was asking because the argument is that it's not an asset because it was canceled, but when you have a land sales contract, it's a certain portion of the amount paid, it becomes a foreclosure, so there is an argument that it's something that's of value.
Well,
So
not
that was
only,
my question, of whether.
we would agree with that, but not only that there was a marital asset, and that Mr. Wiesen's actions dissipated that asset because he failed to take any proper actions to re-up the, to either get financing or redo the land contract. Now, it doesn't make any sense to live in a place as a rental property and invest so much time and money into it if you did not expect a return. What does make sense is that if you were trying to take that money away from your spouse, that you would not take action, no inaction, or inaction, file for a divorce, and then after the divorce is granted, go ahead and finance the home, and now he gets to keep all of it. And I think that that is what Judge Cook drew her conclusions from the facts of this case and the inaction of Mr. Wiesen and his inability to prove beyond his own testimony that he was trying to get financing on this home. And by the testimony of Mr. Hoyt, which certainly indicates that he was open to creating another land contract. They just simply didn't do it.
Is there some case law that if the judge thinks there's fraudulent action here, that she can impute numbers?
Yes, Your Honor, there is. And where I was going to go with that is that not only are we talking these land contracts, he was also using money that was marital income for other things outside of the marriage. And all the while, he had an obligation to his wife that he never fulfilled, and blatantly never fulfilled it. And so I think the court was very much in its own discretion to do what it did based on how he treated the marital funds, his inaction on securing a land contract, as well as his still residing in the residence. When he put the siding on the home, and this is an important point, he was not reimbursed for that. Why would somebody put $115,000 worth of investment into something without even asking for the owner to give them money back for that, or to reimburse them for that work in the parts that were done?
Counsel, correct me if my misunderstanding of what was ordered is wrong, but the trial court did not order him to give her half the cost of the siding. She ordered him to give her half of the appraised value on that residence in which they were not title owner, correct?
That is correct. I'm using the siding as an example of somebody who has intentions of keeping this property and eventually converting that property into his own after the divorce was completed.
But do you interfere with an asset, or if you don't pay, if you're going to have an asset and you don't, and you're supposed to pay an amount to make that asset come to fruition as an investment, do you believe that it can be the subject of financial misconduct? I guess that's the question. This is an investment property that.
Well, I believe what financial misconduct, the way the court found and what we are arguing, is that he had the ability to do this and simply didn't for the purpose of taking away the equity from his wife.
And if he would have done that, then there would,
If he-
that's what she would have had.
Our argument was if he would have done that, or at least provided us evidence that he made efforts, and then went back to Mr. Hoyt and said, hey, let's get another land contract going, then that marital asset would have been in existence. It would have been something that the court could have divided. And because he didn't do that, the argument that he's making now is that, well, I don't own it. But yet you're still living there and you're still investing money into it. Again, back to my original point, actions do speak louder than words, and his actions in this case certainly show that he had every intention of keeping this place and eventually drawing the equity out of it, and was trying to keep Michelle from receiving a single penny from it. With regards to the distribution of debt, which was touched on by Attorney Hoover, again, I would point to the financial misconduct that was conducted by Mr. Wiesen as being something where it was not appropriate to equitably divide the debt half and half because of his spending habits, because of him putting buying the truck and then putting the truck into the business, personally securing that, but not doing anything for purposes of securing the marital residence.
I have a record question. So there's student debt that was incurred before the marriage, that's his debt. Weren't the rest of the debts just for business debts, or are they in his name?
I believe that they were debts from the business that he runs.
In the name of the business?
Correct.
And there was no valuation of the business, his business, or the
There was no
business
business
right?
valuation done on
The
this
business, she
case.
didn't get a value of the cost of the business.
No business valuation was done. I don't believe the parties could have afforded that. But no, that's correct. Nothing like that was testified to or any reports into evidence that would indicate that there was a business evaluation. I think the last thing I wanted to touch on was the award of spousal support. I do think the court was correct in making the spousal support order that it made. The judge went through the factors in great detail, and I think that her reasoning is sound. And about what he would make in the business and what the business was making at the time that the divorce had been filed and at the time that the decision was made. I believe that the court was correct in its analysis and factoring in all of the effort that my client put in to take care of the family and to make the home habitable while they were staying there, especially in the early years where they didn't have any running utilities. I believe that's all I have to know.
As you know, you have 2 minutes and 6 seconds.
Thank you, Your Honors. In terms of rebuttal, I again draw the court's attention to the case law in the Pavlicek court, which stated that each spouse to a marriage must take the responsibility for the benefits accrued from marital assets and also the burdens of the partnership. It is a fundamental characteristic of a marriage, a union which creates a marital estate in which each spouse takes responsibility for both the benefits and burdens. In finding husband at fault for failing to secure this land contract ignores that. It perpetuates the view that husband alone was responsible for the financial security of the marital partnership. In this case, is that even had husband been able to secure the amount for this balloon payment, arguably at the time that the record says it was about $87,000. Even then, it's very clear the parties didn't have $87,000 any which way, and so he would have had to secure financing for that.
Wasn't he the only party to the land sales contract?
No, husband and wife both were.
They both were.
In addition, if the court takes the appraised value of this property of $200,000 and then discounts out the $87,000, which would be owed for a loan, not even counting the interest, it would make the value of the party's equity in that home $113,000 total. In this case, the court found that wife was allocated $115,000 of marital property based on that. In addition, while there was no testimony either way of a attempt to refinance, husband said he attempted to finance, couldn't do it. Wife said she took husband at his word, didn't know if he did. There is nothing in the record on any discovery issues of husband not complying, of a motion to compel being filed, of the trial court raising this issue of why don't I have anything. It was merely he's saying I didn't do it, and there was no other action taken by wife in that litigation to make that an issue.
So let me just go back to the question I asked, and you're out of time, so this will be the last answer.
Understood.
That is in regard to the land contract. I know it was admitted into evidence, but was there any testimony that it had actually been recorded to outline?
No testimony either way on that matter.
Thank you.
Thank you.
And you need to just sum up, or you're done?
I will respect the court's time. Thank you very much.
Thank you very much. And thank you both again for your presentations to the court. The court will take the matter under advisement, issue a written opinion that will be sent to both sides. We also will release on the Ohio Supreme Court website electronically. Thank you again.
Thank you.
Hope you enjoy the rest of your day.